toddlers, teens, and in-betweens. Today we're going to be talking about parenting plan types, order types, and common problems that you may face when going through your divorce. Welcome, Mum. Not every age group is the same, so not every parenting plan or consent order is going to look the same. And on top of that, children grow and children change, so there are going to be issues that people face along the way. So today we want to talk a little bit about that and the common problems that people face and some of the questions we get asked a lot for each of these different age brackets. Now, remembering before we start that this is just a legal discussion, legal education. You should always see a lawyer as each situation is different.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Let's start with babies, because I know you wanted to get into pregnancy, but we have done another episode on that you can go and listen to. But today, let's talk about babies to start with, Mum. What kind of parenting plans do people come up with when they separate from their ex and they've got a baby? Like, that's tricky.
It is tricky because there's this idea that the child at that age benefits mostly from being with the mother from whom they've just been born, and that the father is someone that should see the child for short times and probably more frequently. But the benefit isn't really to the baby. The baby doesn't need more than one carer, and they have one primary attachment. And it can be hard for a new dad or to get their head around that. They can't really spend much time.
What are you saying there, that the age-old 50-50 approach of once someone's split up, that with a baby is not something that is looked at in the court usually?
No, it's not usually considered in the court. So,
and why is that?
Because of primary attachment theory, I've sent a link. And it means that a child under the age of about 3 needs to have a secure attachment to one person. And to interrupt that attachment to one person, it's usually the mother. To interrupt that attachment is to jeopardize their development going forward and their emotional and psychological development and their ability to have relationships in the future that are sound and solid and based on the right things. So it's hard to look at a little baby and think about what sort of adult they're going to be. But a lot of it, according to the science, a lot of what they're going to be is developed in those very early 3 years. And the primary thing is that they need a secure attachment to one person. And a very, very well-regarded, shall we say, social scientist once gave a lecture that I listened to. And he said that to a baby, there are 2 kinds of people. There's mummy and there's not mummy. And the father is, even in an intact marriage, is just the chief of the not the mummy. So that was very controversial when it came out. But 50-50 has really, it doesn't really sit with that idea of a child developing.
So is it still controversial, or is that literally the accepted view of the court?
Well, the thing that I've just sent you is from the New South Wales bench book. So that's for the judges to have on their desks. And so we can access that online. So yes, you can raise that argument, and it is almost universally accepted in terms of, say, no overnights until 3. That's how things have worked out in the past.
So I
think there's still an appetite for that to be the law going forward.
So I guess then there's the element of, well, that's unfair. Because obviously, really, when it comes down to it, you're going to have to choose one parent. And in same-sex couples, there'll be one parent that is obviously the main person. Sometimes it is when it is the male. But how does the court make sure, and how could you put in a parenting plan, or how does the court do orders to make sure that the other parent doesn't miss out?
Well, I think we're asking ourselves the wrong question there. So the child chooses their primary attachment, okay? And it's the best interests of the child that dictates or determines what time they have with other people. So provided the primary attachment is not disturbed, the courts will, and I see it in consent orders too, make orders that perhaps they go to a park and the father plays with the child for a while and comes, or that they might meet at some grandma's house or something for the father to be there, usually in the presence of the mother if there's no family violence. Okay. But yes, because the best interests of the child are paramount, again, I would argue they haven't been for the past 17 years, but because they are now, the court will inform itself via the studies and whatever the experts in child development say. And then I think they'll align their orders that way. So what you've got is your dad becomes a peripheral figure in the child's life, so they're familiar with, and when they're ready for a more sort of developed relationship with their father or the other parent, then that's the step that you move to next.
So to start off with, maybe the parenting plan or the orders are that the baby stays with the main attachment and just has little day visits, etc., with the other parent still there. But then when and how do you gradually change that? Like, what age is it usually when they do start to? Because I do get a lot of messages from people asking about this. They've been the primary carer, they've been looking after the baby, and now the baby's slowly getting older and they're pushing for this overnight time or whatever it is that they're pushing for. So when does the court's view change, and when and how does it change? How does the day-to-day movements of the child change?
Everyone's different. Every child's different, and they may have other vulnerabilities, or they may be very happy to move into overnights as soon as they turn 3. But you have to remember, different kids have different needs as well in your own family. But looking at this little one, it might be that it goes from a couple of hours during the daytime to, say, 9 to 5 on Saturday, 9 to 5 on Sunday, with the primary carer taking the child back home, giving them dinner, bed, all the routine things. And then gradually they extend the time on the Saturday afternoon until it takes over, usually the Saturday night. Okay. And then maybe the child returns to their other parent at 9 o'clock in the morning. So it's just taking it at a pace that suits the child. But unfortunately, when you're talking about court orders, we're crystal ball gazing. And so a court may say, well, from the time they start prep, then they'll be going for the whole weekend and 2 nights, or once they start school, it'll be this. And, we don't know. We don't know how they will develop.
So it's what you're saying is, if it's in court and it's a court order, they will crystal ball gaze and say, okay, by this age, then they'll start having overnights. And then by this age, it'll be more this and this. And it's a stepped order.
Yeah.
But in a parenting plan, I guess, there's no need to lock it in. You just change it as the child ages.
I guess you could put it in their parenting plan that we will look at it again when the child starts primary school. That's kind of the scenario I think that you would be looking at. And with the court's orders, they are set in stone when a court makes those orders. You can, if you need to, go back to court and say, this has changed. The child's got a diagnosis or whatever it is, but you'll have to satisfy the court that it's worth going back into the law. Otherwise, yes, you get these stepped orders and with dates by which things will happen. And just a tip for our listeners, Laura, sometimes when you get an order like that, and I see them occasionally where it says once the child starts school, then it's this, and once they're in grade 2, it might be half the school holidays. If the person whose access it is, the non-primary carer, hasn't been taking advantage of the step-up time, so you haven't seen them, and then they come back and want to take the child half school holidays at 5, that's something you need to look into before you draft up these orders. So sometimes I say, upon a minimum of 8 consecutive one-night visits, then it'll go. So make sure everyone's on that same graduated course for the child.
So you're referring to some of the things that some of our members have mentioned in our Q&As, where they've got these stepped orders. It says that they will have the child come and visit for 3 hours or take them to a park for 3 hours once a week or whatever, but they just don't show up. But then all of a sudden they're like, oh, they get to sleep at my house now, so I'm coming to take them. And it's a big, that had nothing to do with the baby or the toddler at all. And then all of a sudden they want overnight. That is a problem that happens. And you suspect, you've said before, that the minute parents start talking about overnight, it's child support.
Nights. It's child support.
So what you're saying is, that's why it's good to put in your plan or in your consent orders or your orders that they have to have followed the plan to get to that.
Yes. Yes. So you can draft an order quite carefully that says that. And then you would say, for instance, someone had 3 Saturdays with the child and then nothing for months. And then they want to start. I think you'd be quite within your rights for the welfare of the child to at least require some non-overnights first. So yes, but if you've got a court order that locks it in and doesn't make that provision, then you are in a situation, I would suggest, where you could probably go back to court and say, this has happened. We're about to plummet into overnights and half school holidays. And the first familiarisation part of the plan hasn't been followed. So we need that to start again, you know.
And again, mum's just giving a legal education discussion. Go and see your lawyer and talk about this before you take it to court. But it is something that seems to be mentioned a fair bit.
Yeah.
What other problems do people come up across when it comes to babies and toddlers and parenting plans?
Yeah, car seats, keeping on a certain diet. Some people are breastfeeding still, and how you manage that. Mm-hmm. There are a lot of problems.
So how can they make sure that their child's going to be safe with car seats, etc.? Is there something they can put in their orders? Is there something they can put in their parenting plan to ensure that they're going to be safe going from place to place?
Well, you can do the best you can. Of course, you can't reach over into the time with the other parent and know what's happening. But for instance, if someone turned up without a car seat in their car, it's probably an offence to put your child in the car not in a qualified or approved car seat. But if you put it in your orders that provided the person arrives with a suitable car seat for the child, then the child can go. Provided that the person follows the dietary guidelines by the doctor, then the child can go. With the breastfeeding, it's harder. You know, it is harder. It's just odd to feel like you should express milk to send with the baby like that. So you might have to work around that. And people breastfeed up to 3 years now and probably a little bit longer. So what the court has to do, Laura, is just like with attachment theory, they have to have a general idea of child development. And in their general idea of child development, I would say, in my view, it's attachment theory. So up to 3, they must have a secure attachment so they can develop properly. After 3, the court, I think, would normally think the kids are okay to go overnight. That's what the cases are saying, and that's what presumably experts in the field have been giving evidence in the courts. And then usually from time when they start school or maybe when it's prep, something like that, where they're spending a fair bit of time away from their primary carer anyway, the court might then move on to weekends for the children and then maybe a little bit of a Monday or a little bit of a Friday so that kids are being picked up from daycare or school and dropped off at school on the Monday to limit the interaction. But now we have this gold banner that says best interests of the child.
Man. So in regards to that, because we have done an episode about this in the past, but we had to delete it because it's not relevant anymore.
Yeah.
Because you did basically say that the court looks at 50-50, the rights of both parents. It was very up the top there. And you basically said you have to be an axe murderer to not see the kids. And it was very rare for people to not have 50-50.
Yes.
So how has the new changes in the Family Law Act, do you think, changed how primary school kids spending time with each parent?
Yeah. So, and the primary school's up to about 11, from 6 to 11.
And 10, 11.
I think that kids that age, one of the changes is what I've already mentioned, being picked up and dropped off at school. I think, though, the court is more keen now for a child to have a secure base. And I read one writer who said that if the child's got 2 homes, they actually have no home. And it made me think, is a child a sort of person who breezes happily between the 2 households, or do they need a base? And then with your primary school children, if they are going straight from school and back to school, then the parent who is having time with them on those weekends has to supply uniforms and clothes to wear and all of the things that they need for that weekend, because Whilst in the past, you'd pack a bag for your child and it would have whatever was needed, clean clothes, their toys, whatever. Now that doesn't work when the kids have to go to school and be picked up from school and dropped off at school. So it takes a bit of coordination. Yeah, but it's changed. It's not as much weak about now, I think. Your old orders are still standing, but your orders that you might get today don't have to consider 50-50 shared care. That was what was the problem. The judge had to consider 50-50 shared care if they thought that they were going to have equal shared parental responsibility. Now that those strictures have been removed and the court can look at the best interests of the kids.
So at that primary school age, do they ask the kids what they want? Because I guess if you're not in court and you're doing a parenting plan and you're amicable, you could say to the kids, what do you want to do? Or do parents just come up with it themselves? And then in the court, do they listen to what primary school age kids say? Or
there must be many families where the parents work out what's best for their own children. And of course, that's preferable, and if you're both amicable and child focused, you'll probably come up with something that suits the child as well. Primary school children are more aware of separated families, I think, these days because they're going to school and there would be other children of separated parents. They're certainly articulate. I think it's a sliding scale, Laura. So at year one, their views might not be as well given as much weight. That's what the court says. As someone who's 11 and has a view and a strong view, the court would then listen to those children. And one of the things that came out in the reforms and all of the discussions leading up to the reforms on the 6th of May was that kids didn't feel heard. And so now if there's an independent children's lawyer, they should meet with the child over the age of 5. And I guess their views are often relayed that way. But yeah, I don't think you should ask a child in a kind of, do you want this or do you want that? You're going to spend more time with mummy, or what about poor daddy? He's on his own in the flat. That sort of thing. Yeah, but mummy cries when you go. You shouldn't put that pressure on the kids. But if you two come up with a plan, amicable parents, just let the kids know.
But isn't that what family report writers ask the children anyway?
Yeah, they do. They do. But by the time you're there, you've already polarised positions, aren't you? If you've got to court or had a family report, clearly there are two opposing points of view. But if you're amicable and come up with a proposal together, then you can say to the child, this is what we reckon. You're okay with that?
Yeah. Okay. What kind of problems do you see crop up in court when it comes to primary school kids and their orders or getting consent orders or custody issues with primary school?
Primary school.
Yeah.
They forget stuff, leave them at different houses. They have friend groups, and if there's 2 houses, they might not get to spend the weekends with their friends. I think I speak for every parent with primary school kids, is those blooming birthday parties.
I know. At least you get a break. You get a break from having to stand at some kid's birthday party. But Mum, what about that? Because is there something people can do because I've heard of stories where the other party says, don't organise birthday events in my time, or I'm not taking my child to anything because it's my time with the child. People do come up across that. How do you deal with that?
Isn't that terrible though, for your child to feel anxious about mentioning a birthday party because it might be in mummy's time or might be in daddy's time? I think you need to try and get them back to child focused. If you're the parent for most of the time, say, and the birthday party's in that wrong weekend, you could maybe suggest that you could give them some makeup time if they let the child go, or you could pick the child up, take them to the party, drop them back, and they can have a few hours with them next week. It's important for the kids to be able to go, I think, for their social development.
If you do end up with parenting plans are flexible, right? Because they're not set in concrete, which is good and bad because it's not enforceable. But consent orders and court orders are enforceable. So people need to understand, though, that there is an option to still swap days and do make-up time if things don't work out the way you need. Because nobody is going to plan a wedding around someone's time if you're not part of the wedding planning, like, they'll just say, oh, this wedding can such and such go. No one's going to plan their birthdays around the time that they're seeing each parent. So there are all these things in life that, kids are really going to either miss out on or not. So people need to know you can offer to do swap time because it's an order. If you both agree, is that right, Mum? You can change things.
So the first bit, and we all tend to skip over it, but at the top of a document in a consent order, underneath the names, it will say something like that. The children, Jonathan, Seagull, whatever, and such, will spend time with the mother or the father or the respondent, they call it these days, but the father, at all such times as agreed between the parties. So failing agreement as follows, and then there's all of that stuff in an order that's set in stone. But the first bit is at all times agreed between the parties. So what commonly happens is family come over unexpectedly from overseas and want children to be at a place and yep, that's fine. And so I think though, it's hard to get agreement with some people, so you want to make sure orders are pretty clear. Parenting plans. Actually, a parenting plan isn't binding. You can't enforce it. But if someone goes to court for orders about the children, the parenting plan is brought to the attention of the judge and they have to have consideration of it because they'll assume the parenting plan was done before everyone got angry with each other and before the camps. The court will be interested to see what you agreed upon when you weren't fighting so much.
Okay. So even though it's not enforceable, it's still looked at as a court as kind of evidence.
Yep.
Okay. So then we get to the trickier part, and that is teens.
Yes.
Do courts make orders for teens? Can people do parenting plans for teens? Like, how does that work?
Well, at law, the family court has jurisdiction over children until they're 18. So if you get an order when the child is 7, presumably that will go through till their 18th birthday. And you can't go in and ask for new orders generally unless something has changed. And I haven't seen this new legislation tested yet that came on 6th of May where the court says no multiple applications for the child's time to be changed. They want you to try and think it all out early on. And my dream was always that by the time, you get consent orders that say 7 or 8, by the time the child's 12, no one actually knows where the document is and you're all in a routine and it just goes smoothly. But teens are tricky.
So it's really important for anybody who has a baby or a toddler or even early primary school to really sit down and think about their child's entire childhood, because 18, you're no longer a child. So you really need to think about and make sure that what you're writing down and what you're creating as consent orders or what you're arguing for in court, if you're not doing parenting plans, is going to be good enough to get you to the end, because you're saying you can't go back unless there's some significant big change. So it's a hard thing. It might be even a good idea to go and talk to people who have teenagers or people who have like kids at school to say, what am I forgetting about? Is there something that I should be including?
Yeah, I think that's right. And the fact that those orders are supposed to go until they're 18, or you can get orders at 16 that go to their 18, doesn't, I think, reflect real life. By the time a child can get on a bus, drive a car, come home on the train, the court shouldn't be forcing, in my view, the child to continue to spend time. It's not in the child's best interest. If they're going, that's it, I'm done, I'm not going over anymore, and I'm 16, I've got my learner's license and I'm not going. You are in breach if you don't send the children at that age. But the reality is if someone tried to contravene you or bring an application before the court, you'd have to ask, how is it in the best interests of the child, who's not really a child, in their 16, 17, 18, to force them somewhere where they don't want to go. So the court doesn't. They don't usually. And it used to be in the Family Law Act that 14 was the age at which the children's wishes were absolutely determinative. That was whatever they wanted at 14, that's where it went. Now the legislation says the wishes of the children, depending on their age and maturity and understanding, and also, I guess, whether they are being got at by one parent or another to go a particular way. So, yeah, so really it's not a straight, hard line. It kind of fades out towards the 18, really from about 15, 16, 17, 18, the court's not going to make orders against what the child wants. That's the bottom line. And if you've got a situation where you are now with a teenager who is not wanting to go and you're in breach every time they don't go technically, then you might want to think about whether you clarify that with the other side that they're not going to contravene you, or you get some sort of, I don't know, something from their social worker or something, so that the child's views and welfare is front of mind for you. You can't drag a 17-year-old into a car.
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section, where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
Well, I think you've touched on a few points there. Number one is that mental health of teens is quite tricky, especially with all this social media and everything going on, and their focus is no longer on the parents. It's on their friends, it's on school, it's on their life. And the parents are an afterthought. They're literally, the attachment theory has passed long ago, and apparently it's healthy for them to detach from their parents and be different from their parents as a way of becoming their individual selves.
That's right. Yeah.
And that is hard to manage for any family, whether they're separated or together.
And it's hard for the parents too. I mean, when your kids were little, were you going through that awful stage, all of you? I had to get a dog so that someone would greet me when I got home. But it's healthy development. Yeah. And so the parents are dealing with emotions of loss as well, as if they identify too much with their kids.
So I think it's important for psychological counselling, making sure they've got the support they need. We're going through that. Are there any kind of things in orders that people put for teens?
Well, no, really. Here's why. When the legislation said 14, children, and that makes sense, when the child's 14, we listen to their wishes. What developed was a practice of pressuring kids, probably starting as young as 10. Say, when you're 14, you can tell daddy you don't want to see him anymore. When you're 14, you can tell mummy you want to come over more often, or all of that sort of stuff. And the pressure on the kids was immense. Yeah. And then it was, if they weren't going, it was the child's fault and they didn't want to hurt parents. So the court saw that, took that out to take the pressure off the children. And now they don't have technically any date by which they can influence things. Some people think it was 12, some people think it's 14, but actually there's no age in the Family Law Act.
So you touched on that, putting the pressure on the children. At any stage I guess it's hard to put pressure on a baby, but at any stage like toddler all the way up to teens, if there is a parent putting pressure on the other, on the child to ask for more time, does that usually come out in court, or does that usually get discovered, or how can the other parent protect the child from that happening?
I can only speak to the things that I've seen, and it often gets uncovered in family reports. But how often those families go to a family report writer, I don't know. It's not a nice thing for a parent to put pressure on the child for their own ends, or if they just hate the other parent so much they want to. But it comes up a lot. And the court often will remind people this is about the child.
When it comes to the divorce personality types and these different stages of the children, look, obviously, like what you're saying is for amicable, you guys can sit down and create your parenting plan together, create stepped parenting, like say by this age that this will change to this and we'll revisit it at this time. So that, good for you guys if you're amicable. That's fantastic for the children and for yourselves. And keep in mind about the theories of attachment theory and stuff, because some people who do really get along with their ex might feel guilty saying, I feel like it should be 50-50. But if it's a baby, make sure you do the research and you see the effects of that. So amicable is fine. And as the kids express their wishes, the parents listen and things get adjusted.
And respond.
Fantastic.
Yeah.
Avoidant, I guess, isn't really, I guess avoidant would be the parents that just, they're like, I don't actually care, or they don't turn up. So what happens for those people where they don't turn up to pick their children up, or they don't because I've seen some people really angry that their ex isn't coming to take their children. And they ask us all the time, don't they, Mum? How can I enforce my ex to follow the orders to come and collect their child? So what do you say to that for the avoidant types?
Yeah. So I would tip that the avoidant person who entered into orders or parenting plans like that probably did it because that was what was expected. But maybe they're not invested in seeing the children at all. And that's the one order a court can't enforce. You can't force a parent to come and get their children, because how can that be in the best interests of the kids? It'd be awful for them. So you're stuck, I'm afraid, with that. But you're also stuck with having to make the kids available for every occasion. But I think that you could document the non-arrival. You could do it through emails or one of our children things, or you might have messages saying he or she's not coming, or they also might just never communicate. And once that's been going on for a while, then if they were going to try and contravene you in any way, it's them that has contravened the orders. So it's a shield for you.
So if they turn up, say that they have a baby with you, they leave, you've got a parenting plan or a consent order saying that they'll have, and they just don't do any of it. And then they turn up when the kid's halfway through primary school and they've still got the orders and they're like, okay, it's my turn to have the child. What do people do in that situation?
I think you'd put the brakes on there if you can. I don't want to tell people to break orders, but it might be a kind of a but situation. Yeah. Yes, but first of all, we need to go through these things. It might be somewhat shortened because if it's not a baby anymore, but there still needs to be a graduated introduction. I think the court accepts that children should have a relationship with both parents unless there is something that fundamentally means they shouldn't, that the parent can't provide their emotional or psychological or safety needs. Otherwise, for a person to grow up with knowing both parents, even the one that's sort of got warts and all, as Judge Bell used to say, is probably preferable for them to growing up and wondering about the fact that's an argument you can have round and round and round.
Okay. So it's important for people to keep that in mind and document. So if they don't turn up, document, and work towards that. When it comes to high conflict, Mum, the parents that want to fight everything, and I've seen it in our members that they're 5 years, 6 years after relationship has ended, still fighting over a uniform or fighting over who picks up Johnny from soccer or all of that sort of stuff. So what kind of tips do you have for those people that have those hellish relationships with their co-parent?
It's not going to be very helpful what I say, I think, to you guys, because you can't change their personality. What you can change is how you react to it and perhaps limit their communication a little bit. You need clear orders, don't you, for those sort of people?
Yeah. So that's really, when it comes down to it, whilst the children's side of things does seem a lot easier to organise and sort out than property, because property does seem very complicated. The children's side of things, if you do a lazy job, if you do a slap up, just don't think about it too much and just write something and sign it. The problem with that is it can come and bite you in the butt. So you have to create orders that don't have holes in them.
Yeah. And so property is one and done by and large, and you walk away. But children's matters, like you say, drag on officially until the children are 18. And in that time, people will often repartner, and the new partner changes the dynamic, and there might then be the current orders aren't good enough for either side or not working. And the parent who has the kids most might repartner. So there's all this extra stuff in there that could change the orders over time.
Can they go back to mediation even though they've got orders?
Yes, as many times as you like. You can go back to mediation. In fact, that's the preferred thing. And if in reality the child is struggling, and then I would hope both parents would work together to sort of think of something that helps that child and considers all of the children of the relationship, because there might be new children of the new relationship as well. So it's just, children it's a minefield if you've got someone who hasn't got good intentions.
Mm. And that comes to the manipulative and controlling narcissistic type. And I think co-parenting with these people sounds like an absolute nightmare. Are there any tips for court orders or parenting plans with these people?
Yeah, it's hard. Okay, so they'll probably present pretty well to their lawyers and in court. It might be that their new lawyer or their new partner sees them as quite normal people, not manipulative and controlling. But try to be strong. If you've come out of that relationship and you've been always letting things go for the sake of peace, you might need to get some support. Go and see a psychologist. Definitely see a lawyer. And you need to safeguard against your ex manipulating and controlling the children when they're in her care, because that's what they do.
And I think when it comes to the orders and things like that, I've seen and heard people saying to us that my ex fought really hard, tooth and nail, to have all this time with the children, but then just lost interest. And so that can happen with these types if they've got what they wanted. And is it true that sometimes they do it so that they can get a bigger percentage of the property?
Apparently, that's what the Law Reform Commission said, and also painless child support.
Right.
And I think too, the wanting to win or to hurt the other parent is very strong. And one of the ways to do that, if the children have been predominantly yours, your weak spot is the kids. So they were able to attack you and hurt you through that. And that's, I think, when they stop coming and someone says, why have they picking these children up? That's because it wasn't really that wasn't their motivation, keeping time with the children. So yes, so be prepared for that to drop off. Manipulative and controlling. And also there may be some kids who will start saying to the other parent, oh, Daddy says you're this, or Mummy says you're stopping us seeing her, or and the kids come out with it all innocent. And it's like a megaphone in the hand of your former abuser being able to come into your house and tell you. So yeah, it's thick, it's rich.
So if you'd like to learn about what to do if your ex is trash talking you to the kids, or family members are trash talking you to the kids, go and listen to our trash talking episode. Yeah. That is really helpful. I also recommend you listening to our consent orders, it's not rocket science lesson. And we do like to answer people's what if questions. And I did want to go into a whole bunch. There's so many things, but this was just more of an overview of the ways that the court deals with all the different ages. And I know it's hard to kind of foresee what's going to happen in the future, but and like you said, Mum, every situation is different as well. So we didn't even touch on, but we have got an episode on disability that would have a big play on how things get sorted out. But there's so many elements, we can't touch on them all today. But go and listen to the other episodes related to child custody. We touch on all the points that are considered when looking at the best interests of the child in a great episode where you can learn about that. Go and do your research before you just sign some blanket document that they're going to send to you. And the biggest, most important thing I think we can say to you is don't rush into it. Don't make a decision because you feel guilty, and don't make a decision based on you worrying about what other people think of you. And that goes both ways. If you honestly just can't see yourself being a parent, like 50-50 full-time role because you're busy at work, like that's okay. I've seen some of the members in our group where they've just said, look, I'm going to see the kids every second weekend because that's the best for the kids, and the other parent is the primary carer, and that's how it's going to work. And that's great. That if you can acknowledge that and work with that, that's great. If not, if you're both going to be at heads over 50-50, you need to be aware that the court's view is changing.
Yes.
So this feeling that you have a right to see your kid half the time is less and less in the court. Is that right, Mum?
Yeah, that's right. Because the court now says, is it in the child's interests to see both parents equally. Is it in the child's interest to have one base? And it was interesting to hear you say primary carer, because that was the benchmark, the thing we always relied on in before 2006. And then often the kids' status quo, they'd stay in that relationship. But for the last 2 decades nearly, you're not allowed, primary carer was a term that was not used. So I'll be interested to see if the court uses that as a criteria for what's in the best interest of the children. Because especially in interim hearings, they normally go, well, where does the child normally live? What's been happening up till now? All right, we'll continue that until we get a chance to have a final hearing, and we'll take all the evidence. So that we're going on the side of caution by just leaving everything as it is, unless there was some dramatic reason to change things.
And I think that's important. I know we've got to leave it here, but it's important to remember that the judges are doing that. So if you have separated and you're trying to find your feet and you've left your kids with the other person and you're not really getting involved much, if you did get in front of a judge and the first question they're going to ask is, well, what's happening currently?
Yep.
And you do want to spend lots of time with your children, please make sure that you have been spending time with your children and start as you mean to go on, which you say all the time.
I was just going to interject, and start as you mean to go on.
Yes. You say it a lot.
Good.
And look, children is such an emotional situation for the parents because it's their hearts. It's part of them. But on the flip side of that, the children are their own individual human beings. And we really do need to flip this, because the social media barrage of hate that I get about all these sorts of things, but none of it is ever talking about the child's best interest. It's always the parent's best interest. And that is a hard thing to get your head around, because, of course, all you want to do is see your child and hug your child and look after your child. But you really do just have to think about them. And unfortunately, in this world, if you separate, it's really hard to live together until they're 18. So you've got to take one for the team sometimes. And it's a horrible situation to be in. And I wish all of you will be able to amicably sort it out, and that nobody has to go through that horrible pain of not seeing your kids as often. But if that is you, it's okay. Children are only children for 18 years.
And that's right. And they're not really children once they get 15 or 16. And depending on when you separate, it could be a huge chunk of their childhood that's taken up with fighting and litigation. If you have orders that you understand are in the best interest of the children, but you're not seeing them as often as you should, remember that those orders end as the children step into adulthood, and the relationship that you have developed with them, hopefully not coercively making them come over when they couldn't be bothered with either parent, to be honest, at that stage, that will go on because they're adults a lot longer than their kids.
Well, you haven't gotten rid of me, Mum, and I'm in my 40s. so, I think that the thought that it doesn't, the childhood ends, yes, but they're still your children, even when they're 50 and 60, so if your relationship is good and you don't make them hate you by constantly talking about your ex and just all of that, then you will develop a relationship and continue that after when they move out and they live somewhere else anyway. So I know I'm talking very flippantly about this because I know it rips people's hearts out, and that punch in the gut feeling of not seeing your children is real. Like, it's real. So I do send my love to all of you that are listening today, but it's good. This is a good overview episode. Go and have a look at all the other episodes where we go into the nitty-gritty of what the court looks at, and that will help you maybe feel a little bit better, but also understand that the court is changing and the views are changing, and don't give up hope.
Yeah.
All right. Thank you, Mum, for your time.
Thanks,
and we'll see you guys next week.
Okay. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.